Hello and welcome to the summer 2023 update on commercial property, including landlord and tenant. I'm Peter Dollar and I'm going to be presenting this update today. This webinar is part of our regular quarterly update series, and the whole idea is to keep you abreast of key developments, including cases and other changes. And I'm going to be covering the following topics. First of all, on the 1954 Act, Part 2, Landlord and Tenant Act, Part 2, there's a couple of cases, B&M Retail Limited against HSBC Bank Pension Trust, dealing with the terms of a lease renewal under the Act. Then there's Man Limited against Back in Time Diner Limited, dealing with Ground F. And then I'm going to look briefly at the Law Commission's review of the 54 Act. Then there's a couple of cases on modifying restrictive covenants under Section 84 of the Law of Property Act 1925, and those are Quantum Barrowsfield Limited against Bell and Young Commiade. Cases on easements, two cases on easements. Gosling against Bradbury, dealing with a water easement and the ancillary rights that go with it. Bucknell against Alchemy Estates, that deals with the scope of a right-of-way. Then there were attestation issues in the case of Euro Securities and Finance Limited against Barrett. A case on the duty of care owed to a third party when completing land registry forms. That's the case of Seema Ashraf against Lester Dominic solicitors. And liability in nuisance, two cases here. One on Japanese knotweed, Davies against Bridgend County Borough Council, and then Jalla against Shell International, dealing with whether or not a continuing nuisance had occurred. And then the final few areas, sale of land held on a statutory trust under Section 10 of the Open Spaces Act 1906, a bit esoteric, but important if you have to deal with it. That's the case of the Crown Day against Shropshire Council. I'm going to look at the new City of London Law Society Certificate of Title. And finally, the appeal in the case of Pretoria Energy Company against Blankney Estates, the issue of whether or not heads of terms were actually binding. So